Good day, class. We will now continue our discussion on the family code, particularly chapter 2, or the marriages exempted from the license requirement. So, question might be asked, no? Kung suppose, attorney, X would marry Y without a license, what is the status of the marriage of X and Y? So, necessarily and generally, you would answer void na siya, uy, kay wala man ang license requirement, which is one of the formal requisites of marriage. But the marriage is not necessarily void because there are marriages exempted from the license requirement. Unsa ka ni nga mga instances, no? You already know that these are marriage in articulo mortis, marriage in remote places, kana marriage among Muslims and ethnic cultural minorities, and kaning gitawag na to gratification of marital cohabitation. Tagsa-tagsaon na to ang mga provisions nga nag-deal ani nga mga concept, okay? Article 27, when we talk about Article 27, it states that in case either or both of the contracting parties are at the point of death, the marriage may be solemnized without necessity of a marriage license and shall remain valid even if the ailing party subsequently survives. Article 28 provides that if the residence of either party is so located that there is no means of transportation to enable such party to appear personally before the local civil registrar, the marriage may be solemnized without the necessity of a marriage license. So kaning 27, kaning marriage in Articulo Mortis. 28, morning marriage in far areas, okay? Let's look at Article 29. So here, in cases provided for in the two preceding articles, the solemnizing officer shall state in an affidavit executed before the local civil registrar or any other person legally authorized to administer oaths that the marriage was performed in Articulo Mortis or the residence of either party, specifying the barrio or the barangay is so located that there is no means of transportation to enable such party to appear personally before the local civil registrar, and that the officer took the necessary steps to ascertain the ages, relationship of the contracting parties, and the absence of legal impediment to the marriage. Article 30 provides that the original of the affidavit required in the last preceding article, together with a legible copy of the marriage contract, shall be sent by the person solemnizing the marriage to the local civil registrar of the municipality where it was performed within the period of 30 days after the performance of the marriage. Article 31 provides that a marriage in articulo mortis between passengers or crew members may also be solemnized by a ship captain or by an airplane pilot, not only while the ship is at sea or the plane is in flight, but also during stopovers at ports of call. A military commander of a unit, Article 32, a military commander of a unit who is a commissioned officer shall likewise have the authority to solemnize marriages in articulo mortis between persons within the zone of military operation, whether members of the armed forces or civilians. Article 33, marriages among Muslims and among members of the ethnic cultural communities may be performed validly without the necessity of marriage license, provided they are solemnized in accordance with their customs, rites, or practices. Article 34, no license shall be necessary for the marriage of a man and a woman who have lived together as husband and wife for at least 5 years and without any legal impediment to marry each other. The contracting party shall state the foregoing facts in an affidavit before any person authorized by law to administer oaths. The solemnizing officer shall also state under oath that he ascertained the qualifications of the contracting parties and are found no legal impediment to the marriage. Okay? So kaning articles 27, 28, 31, 32, 33, and 34 are situations where ang contracting parties do not have to obtain marriage license before they can enter into a valid marriage. Okay? Kani is also explicitly declared by Article 3, Paragraph 2, no, as exceptions to the formal requirement of a valid marriage license. These exceptions are likewise referred to in Article 9, which provides that a marriage license shall be issued by the local civil registrar of the city or municipality where either of the contracting parties habitually reside, except in a marriage where no license is required in accordance with Chapter 2 of this title. Mao ni ang gipasabot sa Article 9, okay? Also note that except for the Muslims, no, who are now governed by the Code of Muslim Personal Laws of the Philippines, kaning ubang mga various ethnic groups in the Philippines and the contracting parties referred to in the articles that we mentioned earlier, no, must comply with all the essential and formal requisites provided for in Articles 2 and 3 of the Family Code. Also, the solemnizing officer must be authorized to solemnize the marriage under Article 7. Further, their marriage should not fall under those declared as void under Articles 35, 36, 37, 38, 40, 41, 44, and 53 of the Family Code. Even if they are exempt from the marriage license requirements, no, they are not exempt from complying with the other formal and essential requisites of marriage. And of course, they must not be considered void or voidable also as provided for in Articles 35, 36, 37, 38, 40, 41, 44, and 53 of the Family Code. Okay? Um, ang reason ani nga mga exceptions no are mainly anchored on necessity and practicality, such as in the case of marriages in Articulo Mortis, where at least one of the parties is in the brink of death and of remote places, or on respect for and recognition of the customs and practices of Muslims and ethnic minorities, and the policy of the state to as much as possible validate or legitimize illicit cohabitation between persons who do not suffer any legal impediment to marry. Okay? Also note, katong kaganihang provision, kaning Article 28, no? Na ningon diha nga if the residence of either party is so located that there's no means of transportation to enable such party to appear personally before the local civil registrar, the marriage may still be solemnized without the necessity of a marriage license. An institution like marriage should always be encouraged, and without this provision, the illicit relationships may proliferate only because the parties could not get married or because they could not get a marriage license with really no fault on their part. Okay? Layo lang yun kaayo ang ilaha. It's in the bukid and di sila makaabot diri sa local civil registrar, or if they would really pursue to claim that marriage license, let's say magmaan ba ron sila because layo kayo ang ilaha. Okay, so that's the reason why the framers of the family code included this provision, Article 28, into the family code as one of the exceptions to the license requirement. Okay, also note ha na all those who are authorized to solemnize a marriage enumerated in Article 7 and the mayor are empowered to act as the solemnizer of a marriage even without a valid marriage license if either or both of the parties are at the point of death. Okay? From the perspective of Article 27, no? Pwede bisan kinsa nga solemnizing officer, okay? The marriage will remain valid even if the ailing party subsequently survives. The judge must, however, kung siya man gani ang mo solemnize a marriage, must be within his jurisdiction. And kung imam man, priest or rabbi or any minister of a particular sect or religious group, it must comply with the requisites provided for in your Article 7, Paragraph 2. Okay? Ang consul or consul general can only do so if the parties are both Filipinos, as provided for in your Article 7, Paragraph 4, okay? In relation, of course, to Article 10. So, a chief pilot or a ship captain may also solemnize only marriages in Articulo Mortis while the plane is in flight or the ship is at sea, and even during stopovers at port of call. Okay? They can solemnize marriages only among their passengers and crew members. Di manina. As far as the military commander is concerned, he or she must be commissioned officer, which means that his rank or her rank should start from second lieutenant and sign and above. Okay? He or she must likewise be a commander of a unit, which means any subdivision of an army whose strength is laid down by regulations. However, from the deliberations of the Civil Code Revision Committee, it appears that unit has been referred to be at least a battalion. Okay? Also, he or she can only solemnize a marriage if it is in articulo mortis and in the absence of a chaplain. Okay? Kung waray chaplain. And the marriage must be solemnized within the zone of military operation and during such military operation. Okay? The contracting parties may either be members of the armed forces or civilians. For marriages among Muslims and ethnic groups, no, it is interesting to note that under the civil code, for as long as the marriages of ethnic groups, pagans and Muslims were performed in accordance with their customs, rights, and practices, such marriages were considered valid. The previous law even provided that the formal requisites of a marriage need not be complied with, including the authority of the solemnizing officer. The privilege given to these Filipinos, according to the Civil Code, was good only for 20 years from the time of the Civil Code took effect in 1950, unless prolonged or shortened by the President. After the period had lapsed, these Filipinos had to comply with the mandates of the Civil Code just like any other Filipino. Subsequently, the Code of the Muslim Personal Laws of the Philippines was signed on February 4, 1977, and became effective in the same year. So this particular law governs the law on persons and family relations among Muslims. It does not provide that for a marriage to be valid, a marriage license has to be procured by the contracting parties. Dayon, on August 3, 1988, the new family code took effect, expressly providing that Muslims and ethnic groups are exempted from are only exempted from procuring a marriage license for as long as the marriage will be solemnized in accordance with their customs, rights, and practices. In effect, the Code Commission was consistent with the Code of Muslim Personal Laws of the Philippines, insofar as not requiring Muslims to obtain a marriage license. Under RA 6766, or the Organic Act of the Cordillera Autonomous Region, or CAR, Article 10, Section 2 provides that marriages solemnized between or among members of the indigenous tribal group or cultural community in accordance with the indigenous customary laws of the place shall be valid, and the dissolution thereof in accordance with these laws shall be recognized. This law, however, as of the present time, has not yet been properly ratified by the constituents of the region, and therefore, according to Rabuya, may not be effective yet. Okay? Now, for cohabitation for 5 years, with respect to the exemption relative to persons cohabiting for at least 5 years, under Article 34 of the Family Code, it must be observed that their living together as husband and wife must meet two distinctive um, conditions. Una, they must live as such for at least 5 years, characterized by exclusivity and continuity that is unbroken. Ikaduha, they must be without any legal impediment to marry each other. Okay? Una ha, balik, they must live together as husband and wife for at least 5 years, characterized by exclusivity and continuity that is unbroken. Ikaduha, they must be without any legal impediment to marry each other. Okay? In the latest jurisprudence, the prevailing jurisprudence would tell us that the parties should have been capacitated to marry each other during the entire period and not only at the time of marriage. Okay, the basis used by the Supreme Court in the case of Oca versus Necesario was the case of Lineal versus Bayadog. Okay. Also note that the procedure laid down in Articles 29 to 30 of the Family Code relative to the duties of the solemnizing officer with respect to the affidavit that he or she has to execute is merely directory in character. Non-observance of the requirements will not render the marriage void or annullable. Okay. However, under the marriage law, of 1929, any officer, priest, or minister who, having solemnized a marriage in article mortis or any other marriage of an exceptional character, who shall fail to comply with the provisions of Chapter 2 shall be punished by the imprisonment or by imprisonment for not less than 1 year or 2 months, or by a fine not less than 300 or more than 2,000 or both, in the discretion of the court. Okay? So that's Chapter 2. We will discuss Chapter 3 in the next installment of this recorded discussion. Thank you.